Hey, y'all, and welcome to the live stream tonight. We are going to be talking about whether the University of Idaho could destroy or at least severely harm the case against Bryan Kohberger if they tear down the house where the 4 college students were murdered. That's the question we're going to be looking at today. Now, most of you know already the basic facts of the case. You know that 4 college students were murdered at an off-campus house near the University of Idaho. Those 4 students, 5 students had rented the house. 3 of the women who had rented the house were murdered. Also, a man who was visiting one of the 3 women. 2 women were not murdered, who were still in the house. And one of the women technically had moved out, but it was back visiting her friend. So the people who lost their lives that night were Kaylee Goncalves, Maddie Mogen, Xana Kernodle, and Ethan Chapin. The person accused of murdering the 4 of them is Bryan Kohberger. He was a graduate student in criminology studying at a nearby college. The police traced DNA evidence found at the scene back to Bryan Kohberger. He was arrested and he was charged with the crime. Kohberger's trial is set for October 2nd, and he is facing the death penalty. The prosecution has said they will request the death penalty. So welcome everybody who's just coming into the live stream. If you're getting in now after the ads have been running, we're going to be talking about whether the University of Idaho is going to hurt the case against Bryan Kohberger if they tear down the house. So if you're coming in, please hit the like button and subscribe. We would love to have you back for more videos. I also want to say a quick thank you to Randy Kilman, who gave a very generous super chat just as we were shutting down last time, and I didn't get a chance to say thank you, Randy. So the University of Idaho actually owns the house now, and we'll talk about how they came to own it and what they want to do. They want to tear the house down, and we're going to talk about why they want to do that, why the families object to them doing that, and when it ought to happen. So there's a reminder, this whole situation is a reminder that there are really many victims to this murder. The 4 college students are the most obvious and most severe victims of what happened. Obviously, they are the ones most impacted by far. But it's like a pebble thrown into a pool. Ripples spread out and more people are affected. Of course, you have the family members of the people who were murdered. You have boyfriends, you have friends, people who knew them, acquaintances, people who worked with them, employers, and the ripples keep going out and out. And one you might not even think about, another victim, not as obvious, is the person who owned the house that these college students were renting. Now, the person who owned the house owned it in a limited liability company known as an LLC called 1122 King LLC. That's the address of the house. And I want to show you a couple of documents here. This is the house right in the middle there where there's the green. That's the house. And I wish I could circle it for you. But anyway, that's the house right smack in the middle, the little white rectangle there. That's the house where the 5 girls were living and where the 4 people were murdered. This house, as you will see, had, here we go, 6 bedrooms and 3 baths. So you can picture this being sort of the perfect college town house because it has lots of rooms for people to rent. Which is how, of course, college students would like cheaper rent. They don't mind bundling up a bunch of people and living somewhere. And so it's kind of ideal for that. It was obviously a very, I would think it would be a pretty good investment, especially in the location right in the college town. Now, the Zestimate from Zillow says it's worth $456,000 with a range up at as high as $515,000. And it may well have been somebody's retirement plan. Their idea might have been, hey, I'm going to buy this investment house. I'm going to buy it right there at the University of Idaho. I'll get income as I retire. This will be a great idea for investing in my retirement and my future. But think about the impact this murder has had on the house, because it's basically worthless now. I mean, who would want to live there, right? And what parents are going to want to put their kids in a house where 4 people were murdered? Nobody is going to feel secure about that. Nobody's going to want to do that. You could clean the house up all you wanted. There was blood everywhere, but you could clean that up, but you just can't make it desirable after what happened. And so here is what has happened to the house. It is boarded up. Nobody living there, nobody using it. And that's pretty much what you would expect after something like this happened. It really could not be sold given what had happened. It would be very difficult to get value for that. And renting it seems really extremely difficult and unlikely, certainly not at full value. So there was talk about wanting to make the property into a park, but somebody owns it and they need the value for it. So the solution that the person who owns it came up with is they donated it to the University of Idaho. Presumably then it would be a tax write-off, probably at full regular market value without the nightmare of the discount or loss due to the murders. So that was what their solution was. But it created a new problem because the school said, well, we want to tear this down. And the university spokesman, Jody Walker, said, we want it gone before fall semester starts, August 21st. And you can kind of understand the reason for that. The university is thinking, this is bad press. This is terrible having this sitting here. Let's just get rid of it. Let's forget this ever happened. But the families don't want that. Shannon Gray, who is the attorney representing the family of Kaylee, wrote an email to the Idaho Statesman in which she said that the university had asked families what they thought, quote, and then proceeded to ignore those opinions and pursue their own self-interest. The home itself has enormous evidentiary value, as well as being the largest and one of the most important pieces of evidence in the case. Now, according to Shannon Gray, it's not just the family she represents, the Goncalves family, that objects. It's also the Kernodles, and it's also the family of Maddie Mogen. She said she didn't know how the Chapin family felt, and they've made it clear that they wish to avoid being involved in the litigation, in the suit, in the criminal case against Bryan Kohberger. So that's probably why she doesn't really know. Now, so let's talk about the general idea of letting the jury see the case, see the piece of evidence, because what Shannon Gray is essentially saying is this home itself has value as evidence. It's something that the jury might want to see because they want to know, how did the killer move? Where did they move? There are a lot of questions, for example, about the man who was seen by the roommate standing in the door. It's believed, of course, to be Bryan Kohberger she saw, but how, what was the lighting like? How did that happen? And she's saying all of these things are important for the jury to see. This is actual evidence. The house itself is evidence, and the jury may need to see this. So let's talk then about how common is it for the jury to get to see this? And the answer is it's actually very rare for the jury to get to see something like this. Now, you may remember, if you've been following the channel, in the Murdoch case, the judge allowed the jury to go out and to see Moselle, the property where Maggie and Paul were murdered. And this was a New York Times article about it. And notice the first sentence: it is rare for jurors to visit crime scenes. And that's exactly true. It is rare. It's not normal for the jury to visit the crime scene. So I want to talk about 3 things. First, I want to talk about the law. Okay, what's allowed, what's not allowed. And then I want to talk about when it might be really helpful for a jury to see the scene in the house. Then I want to talk about some of the problems that get created. And I'm going to give you my opinion about the house and tearing down the house and all of those sorts of things. So let's take a look first at the law. This is Idaho Rule of Civil Procedure or Criminal Procedure 43, and it talks about the jury this is actually the civil procedure rule, I should say. This talks about the jury going to see any property, place, item, or circumstance relevant to the action. The jury has to be transported as a group under the charge of an officer appointed by the court to the place where the view is to be shown to them. No person may speak with the jurors on any subject connected with the trial of the action during the view, except as authorized by the court. And only the appointed officer may communicate with them in conducting the view pursuant to order of the court. So in other words, it can be done. You can take the jury out to see it, but it has to be very quiet. Nobody is talking through the scene and saying, well, look over here. You'll see this is where the witness was standing. This is where the person believed to be the perpetrator was standing. Here's how they were, how they moved. Here's how they walked. None of that can be happening. It has to be very quiet. And I thought this quote was really interesting in the New York Times article. They talked to one of the jurors from the Parkland shooting case, where the jury was also allowed to visit the high school where the shooting took place. And the juror said, the article said, well, jurors can't typically talk among themselves, and quoted the juror as saying it had been really unique to walk through and process such a disturbing scene without speaking to her colleagues. And she said, you cannot naturally process your emotions in the moment. Your gut is to say, oh my God, did you see X? But you can't. It was quiet. And I can imagine that would be a very surreal, very strange experience to see the scene without any communication at all. But can it make a difference? Well, here's what that same juror said. She said, was it painful? Absolutely. But in going, I think it was helpful because it brings the case to life. Now, you might remember that in the Murdoch case, the defense wanted the jury to go to the property. And this Dick Harpootlian pushed for it on behalf of Alec Murdoch, saying he wanted jurors to be able to see the distance between various geographical points discussed in the case. You may remember that Paul and Maggie were shot down at the kennels, and Alec Murdoch said he was back at the house. So Dick Harpootlian believed seeing how far apart those two were would explain why Alec Murdoch said he never heard a shot. He never actually heard that, and the jury might not believe that if they didn't see how very, very far it was. And he told the court, you just can't really appreciate the spatial issues without actually seeing them, he said in court. So there has, of course, been some discussion that may have backfired in the Murdoch case. The jury seemed to be noting and observing the step into the feed room, and there was question about whether the person might have fallen as they came off that step, which was one of the issues in the case, was whether or not someone had come up to the feed room door or whether Alec Murdoch had shot his son. So, but I also want to talk about, those are some of the, so it definitely could be helpful. It could be helpful for the jury to actually see and visualize where something happened, what it looked like, so they can kind of imagine, okay, here's where it was, here's how it could happen, and they can understand the facts in a better way. But it comes with a significant cost, a downside. And let me ask again, would you mind hitting the like button so this video will get out to more people? I would appreciate that. So one of the downsides is it's expensive to do it, and it's a lot of trouble. You have to transport the entire jury as a group. An officer has to go with them. Usually the court may well go also. The judge may go, some of the attorneys may go. It's a lot of trouble to arrange for the bus, to get people all together, to take them over, and to make sure, especially in a case like this, that nobody talks to, touches, protests, does anything that would influence the jury as the jury sees the scene. The second concern is that things may have changed. You may remember that in the Murdoch case, Creighton Waters, the prosecutor, objected that the trees between the kennel and the house were, quote, markedly taller and thicker. And his suggestion was, okay, maybe the sound, you can see where it would be hard to hear the sound now, but back then the trees were smaller. So that it would have been easier to hear the sound of the gun in the house, and even if he wasn't at the kennels. So, but it also could be something pretty small, like not just trees that have grown up, because In this case, the murder was not very long ago. The murders were just in November of 2022. But it also could be something smaller, like flowers left for the victim, or something that would influence or prejudice the jury. And the court has to really watch for anything about the scene that's different. And the jury has to be told about any differences that there are, or at least the parties have to be given the chance to do that. The third thing is it injects some unpredictability into the trial. And courts hate unpredictability because every single thing that goes wrong is a potential appellate issue. And so the judge is thinking, if somebody talks, if somebody comes up to the jury, if somebody protests nearby, I don't know what the jury is going to see. I don't know. And from the attorney's point of view, I don't even know what they're going to focus on. I don't know what they're going to pay attention to. So there's a lot of unpredictability and risk involved in taking the jury out there. The fourth thing is that it requires that the scene be secured. You may remember in the Murdoch case, there was concern right before the jury went out there that people have been trespassing on the property all weekend and taking photographs. So in the Moscow house, they had to put it under constant watch because they want to avoid people coming up to the house, doing anything from graffiti to vandalism to just going in the house, taking pictures, all of that. And they would have to keep guarding it all the way through trial because at any point something could go wrong where it's destroyed or it's not available and it's changed so much that the jury can't really see it. So, and also the court's going to have to send somebody over right before the jury goes just to make sure absolutely nothing has changed. So the university presently has security assigned. That comes with a cost that's all borne by the university. And then the fifth thing is it's really not clear how long the university would have to do this in order to preserve the house. Trials are often delayed. You don't need to look any further than Chad Daybell's case. Right now, Chad Daybell's case has been delayed all the way until April of next year. So if Bryan Kohberger's case is delayed until December or February or April, then the house will still be there if they agree to keep it until the first trial. And that's the next point. The case is not over after the first trial unless there's an acquittal. If there's an acquittal, that's it, it's over. But in this case, especially with a death penalty case, there's going to be a second phase to determine death. There are going to be appeals, and not just one, there will be multiple layers through state court and federal court in order to determine the issues around the death penalty. The average length of time, close to 20 years for a death penalty case. So at any point in that time, in theory, a court and an appellate court could order a new trial, in theory. So what would that mean? Would the university have to keep the house until the person convicted of the crime was actually executed? That seems pretty difficult. So there's a lot of downside, and that's why these are so rarely done. So I'll give you my view about it, though. And first, I want to talk about why it is that the family wants this. Now, they are very rightly concerned that the trial be 100% perfect, because the prospect of the actual murderer getting away with what happened here is appalling to anyone, If Bryan Kohberger did this, justice absolutely demands that he be convicted. And the families want to do whatever is necessary to convict the right person for this crime. And that's exactly what their attitude should be. Now let's look at it, though, legally. Is it legally necessary to keep the house? No, it's really not. The jury could be shown a video. That may not be as good, but legally, that's plenty good enough. It's not likely, I think, overall, to make a difference in whether Bryan Kohberger is convicted. Letting the jury view the scene is rare, and it should be. If it was done in every case, think about what would happen. You would add time to trials. You would force juries to serve longer periods, which would create a problem. You would add costs to the court and to the parties who have to pay their lawyers longer periods of time. You would add a burden to owners of crime scenes, like the person who owned this house, which now is the University of Idaho. So legally, there's not a need to keep the house. From a legal perspective, it's not required. But, and this is my final point, I guess, like many highly public cases in the modern age, this is really not a legal matter, in my opinion. In my opinion, this is really a matter of public relations and the public perception of justice in this case. In a case this significant, the court is more likely to order a scene visit. For example, if you think about it, you may be thinking, well, Lee says that this is really rare, and yet they allowed a jury to visit in the Parkland shooting case. They allowed a jury to visit in the Murdoch case. That's because those were very high-profile cases. So the court is more likely to order and allow a scene visit in a case like this because of the extreme need for the appearance of justice, the appearance of, in the public, that justice has been served. In my view, the university will get a black eye if it tears this down. Would it be worth it? If the university believes that come fall semester, if they can just get rid of that house, then everyone will forget about what happened. They are just greatly mistaken if they think that. This case is going to trial in the fall. There is nothing additional needed to make the entire community fully aware and to remind them daily about what went on there, other than the fact that the trial is going to happen. I don't think the House adds incrementally more. I think ultimately the university can't win a PR battle with the families, and they would be fighting the families of the victims. It's a bad look. So it will cost to keep the House through the fall, but I think that's less than the cost of the university in terms of public relations damage if something happens. If the trial is postponed, of course, that's a much greater cost to the university. I fully acknowledge that. And I don't know that it would do a lot of good for them to try to strike a deal with the parties, with the families, because if what happened was the case got put off, I think it's very likely the families would just say, no, we really want you to keep it a little longer. It's just 3 months more, 4 months more. And I think it would be difficult for the university to do anything but continue to hold the house for that long. So as you know, we go live Monday, Wednesday, and Fridays at 7 p.m. Eastern Standard Time, but we have a very special plan for next Tuesday. At least it's currently slated for Tuesday. You may remember I talked about the DNA evidence in the Kohberger case, and I have a lot of questions, things I'd like to understand better about the DNA evidence and how that was used to trap Kohberger, how solid those leads are. I asked for suggestions, who could answer these questions for us? Who could help us understand more about the DNA? And the overwhelming answer from a lot of you was CeCe Moore. ABC followed her in a documentary series called The Genetic Detective. She's a non-resident fellow at Harvard and the chief genetic genealogist for Paraben Nanolabs. She heads up their genetic genealogy services for the law enforcement unit. So she has 200, the group does 200 successful identifications of violent criminals in just 2 years. And she said, yes. She said she's going to come on the show. We're currently planning it for Tuesday at 6 p.m. So you definitely want to subscribe. Not only do you want to see what this particular show and what she has to say, but you also want to get the community post, because I'm going to put a post out and ask for your questions. This is an amazing opportunity for us to be able to ask somebody all these questions that we have. So I'm going to put that out and ask you, help me come up with the absolute best questions, the things we really want to know about the DNA evidence. So I'll ask you to put those in the comments to my post. Be sure to subscribe. Here on the channel, we cover the cases everybody's talking about. We make them understandable for everybody. It's the channel where life meets law. So if you would kindly like the video on your way out, and I forgot to load up my outro, so we'll just have to make that it. Thanks for watching, and I will see you Monday at 7 p.m.